2019, and it became effective on May 1, 2020. Now, in our courts of law, courts of law, the purpose of evidence is to establish the truth of a controverted fact. When we say controverted, meaning there is an issue on such fact. In a criminal setting, for example, in a criminal prosecution, the question of fact is whether or not, for example, the accused is guilty of the crime charged. Now, the prosecution will have its own version. The accused on his part will also have another version of the story. Now, the duty of the court, the duty of the judge is to determine which version is truthful. Okay, because the judge, being a person who has not been to the scene of the crime, for example, cannot ascertain for himself or for herself the truthfulness of a certain scenario, for example. So that's why the purpose of evidence is to establish to the court whether or not such fact really existed. Now, the importance of evidence in a judicial proceeding is for the prosecution. On the part of the prosecution, it is to establish a case against the accused. Okay? Now, in a criminal prosecution, there is a quantum of proof required. So, the quantum of proof required in every criminal prosecution is proof beyond reasonable doubt. Now, you cannot convict the accused unless you have a strong proof of his doubt. And the quantum of evidence required is that his guilt must be proven beyond reasonable doubt. So, misking gamay nga doubt, duda, nalampasan na, for example. So, you can only pronounce the guilt of the accused when you have overcome the presumption. Now, on the part of the accused, his duty is the duty of the accused. Okay, the burden in every criminal prosecution, the burden of proof does not lie with the accused. It is always on the prosecution to establish the guilt of the accused beyond reasonable doubt. So actually, wala trabahoon ani ang akusado. It is only to rebut the evidence presented against him or her by the prosecution. No? And that the court cannot rely on the weakness of the evidence of the accused. Maskin pag unsa kahinay ang ebidensya sa accused, dili na magpasabot nga kana siya kanang prisuhunon. The burden will always lie on the strength of the evidence of the prosecution. So, misking unsa kahinay ang depensa sa akusado, dili na magpasabot nga siya diretso mapriso. Okay? The determination of his guilt will always rely on the strength of the evidence of the prosecution. Muna trabaho sa prosecution to establish the guilt of the accused beyond reasonable doubt. Okay? Because there is that statutory presumption, no, sa atong criminal prosecution, there is a presumption that every accused is innocent of the crime unless his guilt is proven beyond reasonable doubt. If the prosecution cannot establish the guilt of the accused beyond reasonable doubt, then the court must pronounce the acquittal of the accused. So, now the evidence, the purpose of evidence is that it will help the court in the determination of questions of facts, because the court is confronted by two versions of facts. No, ingon sa prosecution nga siya ang sad-an, ingon pud sa akusado, usually the alibi of the accused will always be denial or that he was not at the scene of the crime. Either denial, he was not at the scene of the crime, frame up, usually. No, mo na siya ang depensa sa akusado. Now, confronted with these questions of facts, the evidence will help the judge version is reliable, which version is credible, and which version is truthful. Okay? Because the evidence will help the judge reconstruct the chain of events from the conception up to the consummation of a criminal design. So that is why in the prosecution, in criminal prosecution, for example, so there will be dates set for the prosecution, dates which allow the prosecution to establish his evidence. Now there will also be dates determined for the accused so that the accused can controvert the allegations raised against him by the prosecution. Now, with all this presentation of evidence, the court will be able to reconstruct in his mind, based on the evidence offered, what really transpired, what really happened, and will help the judge in his resolution of whether or not the accused should be convicted of the crime charged. So unsa ning evidence? Evidence is the means sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Evidence means kuana siya, kining pamaagi so that in a judicial proceeding the court will be able to ascertain the truth respecting a matter of fact. As said earlier, kini siya makatabang sa korte na ma-identify, ma-determine ang the truthful version of the story, because there will always be two versions of the story in a trial. Okay? So evidence is the means, meaning pamaagi, sanctioned by these rules. When we say rules, by the rules of court, no? Kinahanglan sanctioned siya, meaning allowed. Because in a court proceeding, you are not allowed to offer something that is not admissible, that is excluded by the rules, and is not allowed by law. No? It should be sanctioned by these rules, sanctioned by the rules of court, sanctioned by the law. Okay? By the Constitution, by established laws of ascertaining in a judicial proceeding the truth respecting a matter of fact. Dili ka magpataka o presenta og ebidensya na kana nga ebidensya gibawal sa korte, no? Dili siya allowed, gibawal, or violative sa rights sa accused. So muna siya. So sa evidence no, nakabisita man siguro mong korte, nakapaminaw mong trial, kana ganing once mag-present og evidence tapos na objection, na grounds of objection, for example, inadmissible, okay, or violative of the right of the accused, then the same should not be admitted because it is not sanctioned by the rules. It is not sanctioned by law. When we say sanctioned, dili siya authorized, dili siya allowed. So we have concepts of evidence. One, it is a means of ascertainment, meaning pamaagi siya para mahibaw-an, no, kung unsay tinuod, kung unsay dili tinuod. Ikaduha, sanctioned by the rules of court. Pag may muntag sanction, meaning allowed. Kung allowed gani, meaning dili siya excluded, it is authorized, no? So allowed siya. Tapos asa man na nato ipresenta ang ebidensya because we are talking of a court proceeding. So dito sa korte, in a judicial proceeding. So when we say proceeding, there are rules to follow. No, dili lang kay basta-basta presenta dire, presenta dito. So we have to follow a set of rules. And it pertains to the truth respecting a matter of fact. So on the part of the accused, naa siya iyahang version sa ebidensya. Sa part pud sa akusado, naa pud siya iyahang version. So the two versions, that of the prosecution and the defense, cannot really coincide. Pwede in some aspects mo coincide, but not totally in all aspects. That's why there will always be factual issues. So kani nga factual issues mo ni siya i-resolba sa court, no? Pag ma-resolba ni niya, iyang gamiton ang mga ebidensya nga gipresenta in a judicial proceeding during the course of the proceeding. admissible ang evidence? Evidence is admissible when it is relevant to the issue and is not excluded by the law or the rules. So ang ebidensya ko no, admissible kung relevant siya sa issue and is not excluded by the law or the rules. Kanus aman relevant ang evidence. So when we say evidence is relevant, meaning the evidence has bearing to the issue. It will tend to establish the existence or non-existence of a fact. For example, in a criminal prosecution for violation of the Dangerous Drugs Act of 2002, particularly Section 5, Article 2 thereof, which penalizes the selling of illegal drugs. Okay? The presentation in court of the corpus delicti, which is the drug itself, no, subject of the buy-bust operation, is it relevant? Is the presentation of the corpus delicti to the court relevant evidence? Yes, it is relevant evidence because it establishes the corpus delicti of the crime, and without it, you cannot build a good case for violation of Section 5 against the accused. So the subject of the buy-bust operation must be presented to the case. Why is it relevant? Because it constitutes the corpus delicti of the crime, and without it, the accused cannot be convicted. Okay? And second, it should not be excluded by the law or the rules. Another example is, for example, there was a buy-bust operation. There was an alleged buy-bust operation, and that the accused was able to establish that the evidence against him, the sachet of drug allegedly recovered from him, was planted by the members of the apprehending team, by the buy-bust team. Now, if the accused was able to establish that the evidence was planted, question, should the court admit the evidence? Is the sachet relevant? Yes, it is relevant because allegedly it is the corpus delicti of the crime. But the question is, should it be admitted? No, it should not be admitted because it is excluded by the law. Why is it excluded? It should not be admitted by the court because it is a fruit of a poisonous tree. No? It was planted, and it should be excluded. It should not be admissible because it is violative of the right of the accused. No? It's constitutional right. So the question is the presentation of the sachet allegedly recovered during a buy-bust operation from the accused relevant? Yes, it is relevant because according to the prosecution, it was allegedly recovered during a buy-bust operation. But the question is, should it be admitted? No, because under the circumstances, it was said that the same was that the sachet was successfully established by the prosecution to have been planted by the members of the buy-bust team. So it should not be admitted because it is a fruit of a poisonous tree. And when we say fruit of a poisonous tree, it becomes violative of the constitutional rights of the accused, and therefore it should not be admitted as evidence. On the rule of relevancy of evidence. Now, evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Now, evidence when during trial, for example, in the early stage of trial, we have that pre-trial stage. It is a mandatory requirement of the law that in every criminal case there should be a pre-trial, no? Pre-trial. Now, during the pre-trial, the among other things that will be agreed upon or that will be laid before the court is a rundown of what evidence to present. There should be no surprises inside the courtroom, no? So the evidence for the prosecution will be initially marked, and again the evidence of the accused will be marked as well. Now there will be no surprises, so there will be a rundown of evidence for the prosecution and rundown of evidence for the accused. Now the evidence laid down by the prosecution must have a relation to the fact in issue. For example, if the charge involves murder, for example, okay. So the evidence for the prosecution most probably will contain the testimonial evidence of the private complainant, the testimonial evidence of the medical legal, the documentary evidence consisting of the medical legal report, the all the documents from the doctors, from the hospital, from the billing, so that will constitute the expenses, for example, that will constitute the documentary evidence on the part of the prosecution. The weapon used in killing the victim, that is irrelevant evidence. Okay, those are relevant evidence. What else? The receipts from the hospitals, receipts from the pharmacies. So those will constitute relevant evidence. So they will help establish the fact that the crime of murder has been committed and that the accused is probably guilty thereof. Unsa pa? CCTV. No, nakita, CCTV, the uh, the weapon used in killing the victim, those are relevant evidence. So it will help the prosecution establish the existence of murder. Okay? Now, on the part of the accused, for example, what will, for example, be relevant evidence on the part of the accused in a crime for murder? For example, if his defense is alibi that he was somewhere else at the time of the commission of the crime, he was abroad, then he could present his travel documents, no, katong sa web case, like for example, unsa pa? A CCTV sa akusado. Testimonial evidence sa katuyang kauban nga tinuod magpamatuod nga wala siya atong higayuna nga na himo ang krimen. Pwede siya. Those are relevant evidence. Relevant will have a relation fact in issue. Meaning nasa relasyon nga issue sa korte, pwede na siya ipresenta as long as dili siya excluded by the law, no, or the rules. Pwede siya ipresenta. Pero relevant man gani siya, pero excluded siya sa law or sa rules, or it was obtained in violation of the constitutional right of the accused, then it should not be admitted in court. Evidence, no matter how relevant, if it is violative of the constitutional right of the accused, if it is violative of the law or violative of the rules on evidence, it should not be admitted by the court. Okay? No matter how relevant and no matter how strong its potential of establishing the fact in issue is, no, dili na siya dawaton. Now, evidence on collateral matters. Now, saan yung evidence on collateral matters? When we say collateral matters, those are side matters. Okay? Now, usa man ni dawatonon ba ning mga evidence on collateral matters? No? General rule, ang collateral matters, evidence on collateral matters should not be allowed. Na exception when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. So, general rule, evidence on collateral matters should not be allowed. Unsay exception? Exception kung kini siya nga collateral matters, ebidensya on collateral muna siya. So anyway, are there any questions? Na mga pangutana?
Yes, ma'am. Kanang kuan ma'am ba? Kanang gitawag na nga hearsay evidence, ma'am. Applicable ba po na siya ani nga kuan ma'am sa korte, ma'am? Or pwede ba nato siya i-admit, ma'am?
Oh. So, unya no, ato na siyang i-discuss, but for purposes of your question, hearsay evidence generally is not admissible. No? Dili admissible ang hearsay evidence because the courts should rely on reliable testimonies. Dili nang what you hear, then you say in court without basis. No? So, generally, hearsay evidence is not reliable. However, there are exceptions to the rule, then which we will discuss later. Okay?
Thank you, ma'am.
So, okay. Now, unsa man yung mga different kinds of evidence? So, naatay object evidence, naatay documentary evidence, naay testimonial, naay relevant evidence, material evidence, there is competent evidence, direct evidence, circumstantial evidence, cumulative evidence, corroborative evidence, and prima facie evidence. Natay prima facie evidence, conclusive evidence, positive evidence, negative evidence, rebutting evidence. So daghan kay klase sa ebidensya, no? So unsa man ning object evidence? Object meaning those evidence which you can address to your senses. Okay? You can touch it. Mga tangible things ba? Or that those are capable of being demonstrated in open court. When we say in open court, those which can be demonstrated during court proceedings. No? Open court meaning while the court is in session. Now, the court can touch it, the court can see it, the court can that which can be addressed to the senses of the court. Okay? So for example, object in a case of carnapping, for example, of a motor vehicle, no, na ay the pick lock, for example, no, which was used in starting the engine of a motorcycle. It's an object evidence because you can see it, you can feel it, you can present it to the court. Okay, object evidence. Unsa pa man, that which you can see in an ocular inspection, the motorcycle, object evidence, imong makita, imong mahikap, imong ma-inspect. So muna siya object evidence. No? You can exhibit it. You can demonstrate. Then object evidence is always relevant regardless of contents. Because object is, we focus on the thing, the tangible thing. Okay? We do not focus on the contents of such thing. So it is always, the object is always relevant. Misking unsa pa nang sulod ana, misking unsa pa nakasulat ana, when the purpose of the evidence is to present it as an object evidence, then no matter what the contents of the documents are, so it doesn't matter. Because ang atong katuyuan, ang pagpresenta atong object evidence. For example, okay, in a case of murder, for example, and the weapon used in killing the victim was a stone, no, stone. Then during the investigation, the blood-stained stone was recovered, no, katong nagkadugo pa nga bato na nakuha. Then katong batuha natoy sulat, kanang nakasulat kanang si Fe Love Maria. Kaya dito sa park man nahitabo, no, na inscription ang stone. Then the prosecution offered the stone as object evidence. Okay, is the stone admissible in evidence? Yes, it is admissible because it is relevant to the fact in issue. It will establish the probability that a crime of murder has been committed and the weapon used was the stone. Actually, the blood-stained stone. Okay? Does the inscription on the stone matter in the presentation of the evidence? No, it does not matter. No? Unsa man ni judge? So man nga Fe Love Jose. So the inscription in the stone will not matter. Okay? Because the purpose in the presentation of the stone is to prove that it was the weapon used in killing the victim. In fact, it was stained with the blood of the victim. So, claro? So that's object evidence. No, misking unsa, regardless of the inscription of the object, it doesn't matter, because our concern is that the thing presented in court will help in the establishment of the probability of the fact in issue. On the part of the prosecution, the probability that the crime, Bert, so the probability that a crime has been committed using the stone as a weapon. Now, the second kind of evidence is documentary evidence. Unsa maning documentary evidence? Evidence supplied by written instruments or derived from conventional symbols, such as letter or ideas presented on material substance. Okay? So, documentary evidence, now, we rely on the inscription, no, mga written instruments, symbols, letters, or ideas presented on material substance. Now, for example, we go back to the murder case, no? Katong ganiha. Katong bato was presented, for example, pwede ba tong bato i-present sa prosecution nga documentary evidence? Pwede ba? Pwede siya, dili.
Dili, ma'am.
Ang pwede. Ha?
Kaya ang document, ma'am, kay
Pwede,
supply
dili.
by written instruments. Mong dili siya.
So, dili. No, akong balik ko na example ganiha. Karon nato sa documentary evidence. If, for example, ang purpose of prosecution is ipresenta. Excuse me ha, excuse me class. Hello? Documentary evidence. Now, the question is, in a murder case, the stone was presented by the prosecution in court to prove that Fe and Jose are lovers. Can the stone be admitted as documentary evidence? Yes.
Yes, ma'am. Yes,
Yes.
ma'am. Yes, ma'am.
Yes. Because the purpose of the offer is to prove the inscription in the stone, di ba? To prove that Fe and Jose were once lovers. Because, for example, we are dealing with the crime of Jose killing Fe. Okay? Now, to prove that Fe and Jose were lovers, the prosecution presented the stone as documentary evidence showing the inscription of the stone. For example, Fe, heart, Jose. Okay? So in that case, the stone can be admitted as documentary evidence because the purpose of the offer is to prove the symbols or the inscription in the stone. Claro?
Yes,
So it
ma'am.
will depend on the offer. Okay? If the stone is offered by the prosecution as as evidence that the same was used as a weapon to kill the victim, then the stone is object evidence. Claro? To prove that the same was the weapon used. Pero if the purpose of the offer of evidence is to prove the inscription in the stone, not prior, for example, to the death of Fe, okay, there was a written note in the stone, and that will probably tend to establish the fact that Fe and Jose were once lovers, then the stone will be treated as documentary evidence. Kay ang purpose man sa prosecution paghatag sa ebidensya kay katumang nakasulat sa bato, dili man ang bato, di ba? It just so nga ang sulat dito nabutang sa bato. So the stone will be treated as documentary evidence. So klaro to? Okay? So do not be confused. You rely on the purpose, no? To in determining whether the evidence is either object or documentary, you scrutinize the offer made by the prosecution, no? Inyong tukion unsay purpose sa offer. Kung ang purpose sa offer sa prosecution is to submit it to the court as a weapon, for example, then that is object evidence. But if the same, for example, was offered to prove the inscription in the thing, then that's documentary evidence. Okay? Like for example, gidunggab kag ballpen. Okay? So the ballpen, the weapon used is object evidence. Pero if the purpose of the prosecution is naay inscription ang ballpen, no, naisulat dito sa ballpen, then the ballpen is documentary evidence. If the prosecution, if the purpose of the prosecution in offering the pen is to prove the inscription, the symbols or the letters written on it, then the ballpen is documentary evidence. Now, testimonial evidence. Something testimonial evidence. Testimonial evidence kanang mulingkod na ang mga testigo para muhatag sa ilang testimonya, no? Sa korte. Dapat tayo gitawag nga deposition, no? Ilang mga affidavits. Okay? If for example, unsa man ning deposition, ma'am? Kining deposition kana betong dili makatungha ang akusado ay ang testigo sa korte, no? There will be that the witness cannot be available on the scheduled date and time. So the counsels could move for the taking of the deposition of a witness. Kwaon daan iyang testimonya. So there are rules on how to take down the deposition of a witness, no? And this deposition of a witness will constitute as the testimonial evidence of the witness in lieu of his presence in the court, no? Ang equivalent aning deposition, equivalent gihapon ni siya sa testimonial evidence sa testigo nga dili posible makatungha sa korte, no? Identified siya sa pre-trial as isa sa mga testigo nga mohatag sa iyang testimonya, pero anang higayuna og orasa nga gihatag sa iya sa korte di siya makatungha, for example, dili siya available, so pwede ang counsel, ang proponent sa witness, no, katong gusto mo offer siyang testimonya, pwede siya mo submit og motion sa korte nga kwaon ang deposition sa iyang testigo. Now, it will be a different, the taking of deposition is covered by the different rules, no? Different rules sa rules of court. Now, anyway, it is equivalent to the testimonial evidence of the witness. Testimonial, no, kanang maghatag ka, magpresenta ka, siguro ka mo, nakabisita mo sa korte, nakatanaw mo, kanang mo testigo ang korte, no, sa hearing. So, kana iyang gihatag ng testimonya, mo na siya testimonial evidence. Unsaon man na, ma'am? So, the testimonial evidence of the witnesses are recorded, no? Because we are courts of record. Everything happening inside the court is recorded. The testimonial evidence of the witnesses are recorded by the stenographers, and they will form part of the records of the case. So, in cases of appeal, the transcript of the testimonies of the witnesses will, together with the records of the case, will be forwarded to the appellate court, no? So those are testimonial evidence. So relevant evidence. So atong gisgutan ganihan, no, kanang naay kalambigitan sa gituki nga issue sa korte. So for example, ang issue sa murder nga gipasaka nga kaso nga murder kang Juan, ang issue ana whether or not, no, gipatay si Juan ni Jose, whether or not Jose killed Juan. Una siya factual issue sa kaso nga murder. Tinuod ba gyud nga si Juan? So mo na siya. So unsa bang mga ebidensya ipresenta nato ana? Tanang ebidensya nga naay kalambigitan nga makatabang sa pag-establish kung tinuod ba nga gipatay ni Juan si Jose o wala. Sa prosecution iyang ihatag nga mga ebidensya nga si Juan nagpatay ni Jose. Sa bahin pod ni Jose, sa katong mga testigo pod ni sa katong sa bahin pod sa akusado, ang iya pong mga ebidensya nga ipresenta kato pong na ay relevant sa iyang depensa nga dili tinuod nga siya gapatay ni Jose. Ana no? So relevant as long as it has bearing to the fact in issue and it will tend to establish the probability or improbability of the fact in issue. Okay? On a condition that the said evidence should not be excluded by the rules and it is not excluded by the law. Meaning, dili siya violative of the rules on evidence, dili siya violative of the constitutional rights of the accused, dili siya violative sa uban pang mga balaod. Okay? Klaro? Evidence is directed to prove a fact in issue as determined by the rules of substantive law and pleadings. So material. So priya siya sa relevant no material siya. Meaning again it will help in the establishment of whether or not a fact has been committed. Again on the part of the prosecution that the accused committed the crime, on the part of the accused that he did not commit the crime. Okay? Unsa man ang competent? Competent. Evidence is competent when it is not excluded by the law or the rules in a particular case. No? Competent siya, meaning posible, makatabang. It is competent. Posible makatabang sa fact in issue. No? Competent when it is not excluded by the law. Direct that which proves the fact in dispute without the aid of any inference or presumption. It is sa wailangan klaro nga kana siya ebidensya. Okay? Niya ang motorsiklo. Okay? So that's direct evidence. Sa katong nakakita, nagisakyan ang motor, gipaandar o gipadagan, katong testimonya atong nakakita is a direct evidence. There's no need for inference, there's no need for presumption. The witness of the testimony is a direct evidence that he saw that the motorcycle of someone was carnapped and that accused is not the owner thereof, carnapped the vehicle of someone else. No? Muna siya direct, klaro, clear and straightforward. Dili na kinaglag haka-haka. Klaro, nakakita ka. So, way pasumbingay, klaro ang ebidensya. That's direct evidence. Circumstantial evidence. Unsa nang circumstantial evidence? Dili siya direct, but kung tahi-tahion nimo ang mga nahitabo, it could lead to no other inference. No? Walay lain nga padulngan sa inference than a suggestion that nga posible nga siya ang nag-commit. For example, like, unsay example sa circumstantial evidence? Walay nakakita nga gipatay ni Pedro si Juan. Okay, walay nakakita. Pero naay nakakita ni Pedro nga anang orasa, anang pitsaha, diha nga lugar, naggikan si Pedro. Okay? Nagkadugo iyang sanina na ay dala nga bolo, ang bolo nagkadugo. Dayon nakita siya nga, for example, na ako'y nakakita sa iya, nga iyang gihugasan iyang bolo, iyang gilabhan iyang duguan nga sanina. So sa mga nakakita, the testimonies of these witnesses who saw Pedro coming from the scene of the crime, no, holding a bloody bolo, and his shirt was bloodstained. Tapos katupong testigo sa witness nga nakakita siya nga anang mga orasa, dihang lugara, anang pitsaha, diha niya nakita nga si Pedro nagkadugo, yang nanghugas siya, yang gihugasan niyang bolo. So these are circumstantial evidence ka posible si Pedro ang nipatay ni Juan. Kay kan anang higayuna, anang hitabua, anang orasa, nakita siya, ana, dayon, ang weapon, upon examination, the weapon used in killing Juan was a bolo. So kana siya nga mga circumstansya, puhon mga testigo sa mga witnesses, no? These are circumstantial evidence which will tend to prove that Pedro might be probably guilty of the crime and might be the one who killed Juan. So these are circumstantial evidence kanang mga hitabo nga nagpalibot sa posibilidad na ang isa ka krimen na nakomit. Okay? Cumulative evidence. Umsa ang cumulative? Meaning the sum total of the evidence. Kung tanan nga ebidensya, no, imong kwaon, ang testimonial evidence, ang documentary evidence, ang circumstantial evidence, ang direct evidence, imo na silang tahi-tahion, imo na silang i-combine tanan, so that's cumulative, no? So, cumulative evidence meaning when a sum total of all the evidence would lead to no other conclusion than a conclusion that the accused is guilty of the crime, no? Tanan na ebidensya, cumulative, meaning the sum total of all the evidence. So, in arriving at a decision of whether or not the accused is guilty as charged, okay, the court will consider the cumulative evidence, ang tanang ebidensya, dili lang kay ang testimonial, dili lang ang documentary, okay, dili lang ang circumstantial evidence, tanang ebidensya, the sum total of all evidence. And that sum total of evidence should lead to no other conclusion than a conclusion that the accused is guilty of a crime beyond reasonable doubt. So na ginapirmi ng beyond reasonable doubt, no? Dili ta mahuman sa guilty of the crime, dapat na ay beyond reasonable doubt. Kung moingon tag beyond reasonable doubt sa walay duda, okay, meaning that the court has surpassed the moral, the moral question in the determination of whether or not the accused is guilty of the charge. Meaning sa iyang konsensya, walay klaro, sa iyang konsensya, klaro nga ang accused ang nakabuhat sa krimen. Okay? Because in every criminal prosecution, the quantum of proof required is proof beyond reasonable doubt. Okay? Proof meaning sa walay gamay nga duda na pamatud-an nga ang akusado maoy nakabuhat sa salaod. Mao na siya, no? Proof beyond reasonable doubt. Nga ang korte mismo sa iyang moral nga conviction, okay? Nagtuo nga ang akusado ang akusado mooy nakabuhat sa salaod. That's why in that instance, the court will pronounce the guilt of the accused. You know, class, in judicial proceedings, the presentation and the appreciation of evidence is very vital, no? Dapat kabalo ang mopresenta sa ebidensya, ang huwis pod kabalo nga mo-assess o mo-appreciate sa evidence. Otherwise, the accused will be convicted not because he is guilty, but because there was failure on the part of his lawyer to very well present his evidence, or there was failure on the part of the judge to appreciate well the evidence. So yung anak ka, importante ang ebidensya. Posible, no? Kay, syempre, human error. We cannot negate human error. Ang mga huwis, aura ang huwis, no? So, kinahanglan ma-appreciate niya ug ang abogado sa akusado dapat kabalo mo presenta sa ebidensya. Otherwise, mapriso ang akusado dili tungod kay sad-an siya kay tungod wala mainsakto og presenta iyang ebidensya. And that's a very difficult scenario on the part of the justice system, no? Kanang mapriso nga way sala nan. So that is why the lawyers are guided by the rules on evidence in the presentation of evidence, and the court as well is guided by the rules on evidence in the appreciation of evidence. Okay? So, if only to serve justice, then the lawyers as officers of the court have the bounden duty to present well the case of his client, and the court to appreciate very well in accordance with law the evidence presented before him or her, so that justice will be served. Okay? So muna siya. So that's how delicate the presentation and appreciation of evidence is. Dili lang ni basta-basta kay dinhi nakasalalay ang kagawasan o kagawasan sa usa ka na akusa og isa ka kaso. Yang kagawasan o ang kuan na diri nakasalalay ang iyang liberty, no? So muna siya. Unsa maning corroborative evidence? Corroborative evidence kani siya nga mga ebidensya are also relevant, but kung tan-aw sa korte nga daghan na kay corroborative evidence, the court may opt not to anymore admit the corroborative evidence. Kay kini mga corroborative evidence, mga additional evidence ra man ni sila ba? Although they can strengthen the evidence earlier presented, but kung tan-aw sa huwes na warag insakto ng ebidensya, the court may opt not to anymore admit evidence that are merely corroborative. Kay their purpose is only to add to an existing evidence, so that kung sa pundasyon pa ni makapalig-on samot sa pundasyon. Pero kung tan-aw sa hukmanan o tan-aw sa iyang abogado nga lig-on ang pundasyon sa iyang kaso, there's no need more, no? Wala na di na manginahanglan nga ipresenta pa ni or admit pa ning corroborative evidence, because its purpose is only to strengthen an already existing evidence. Okay, corroborative. So the court, ang judge mo man na siya kung sa barko pa mo na siya piloto sa barko, mo na siya kapitan. So mo nang kanang pre-trial conference nga mahitabo, which is a mandatory requirement in every criminal proceeding, dapat i-determine na dira, no, ang mga ebidensya nga ipresenta. Kung tan-aw na sa korte nga daghan na kay ebidensya, then ang ilang purpose is muadra or balik-balik, pwede na dili na ipresenta, no? Kung magbalik-balik lang ang testimonya, muad lang, so dili na, pwede na dili na. Unsa man ning prima facie evidence? Kaning prima facie evidence, if the evidence which can stand alone to support a conviction unless rebutted, if unexplained or uncontradicted, okay, kining prima facie evidence is evidence if existing, if unrebutted, is sufficient to convict an accused. Unsa man ang prima facie evidence? Okay? Wala siya. For example, nagpresenta ang prosecution og mouna siya nga ebidensya. Okay? Wala siya gilalis sa pikas. Wala siya gi-controvert. Okay? Wala siya gi-contradict. So it will be enough to pronounce the conviction of the accused. Okay? Lain na siya sa conclusive evidence. Kaya mingon ka conclusive evidence, kato dili na to siya kinahanglan i-rebut, dili na to kinahanglan i-contradict. No, mo na dito siya ang conclusive evidence. Kining prima facie mo na siya bali sa conclusive evidence. Pwede na siya nga ebidensya kung wala ma-rebut will be sufficient to allow a judgment of conviction. Pero kung rebutted, posible nga it can help in the pronouncement of a judgment of acquittal in favor of the accused. No? So prima facie evidence is evidence which can stand alone to support a conviction unless rebutted. If unexplained or uncontradicted, is sufficient to maintain a proposition. Okay? For example, no, sa civil case, prima facie evidence. For example, naakay utang, no, naakay utang. Karon, naakay document nga tinuod utangan ka. Okay? So katong nangutang, if moingon tong isa nga wa pa siya kabayad sa utang, okay? Kung moingon siya sa korte nga wala pa siya kabayad sa utang, kung dili i-rebut sa nangutang, okay? It will allow the court to issue a judgment in favor of the creditor. Nga tinuod wala siya nakautang kay wala niya gi-rebut. Okay? Pero kung ang katong nangutang makapresenta siya ebidensya, no, acknowledgement receipt baron sa iyang payment, pakita nga nakabayad man ko. Okay? So unsa na? So na-controvert niya ang gi-allege sa creditor nga wa pa siya kabayad sa iyang utang. The debtor was able to controvert the proposition of the creditor by showing a contrary evidence, that is the acknowledgement receipt of payment. Muna siya. Pero kung imong pasagdaan ang aligasyon, wala ni mo gi-contradict, wala ni mo gi head on, wala ni mo gi-contradict, wala ni mo gi-rebut, so magpabilin to siya sa kwan sa okay, kaya wala man gi-argue, wala gi-rebut, wala gi-contradict, so mo siguro ni. Pero kung ikaw nagpakita ka og ebidensya nga mo contradict sa allegation, then it could probably help the court in the resolution of the case in favor of the one presenting a rebuttal evidence or a contradictory evidence. So that's prima facie evidence. Conclusive evidence. Unsa man ning conclusive evidence? Ang conclusive evidence mo ni siya ebidensya na nga dili na kinahanglan i-rebut. Dili na pud siya mo contradict, no? Di ni siya ma-contradict, dili ni mo ma-rebut. Conclusive ni siya nga evidence, meaning conclusion. Human na. Sa way langay, walay daghang storya, mauna siya. Mauna siya ay conclusive evidence. No? Conclusive evidence. No? Conclusive evidence, ebidensya nga dili na i-allow sa balaod na i-contradict nimo. Okay? What are these conclusive evidence? Examples of conclusive evidence. For example, conclusive evidence diri sa Pilipinas nga ang atong season, we have dry and wet season. So those are conclusive evidence. Di na nimo kinahanglan i-rebut. Alangag mo rebut ka nga natay winter diri sa Pilipinas. Murag wala pa siguro. So that's conclusive evidence that the Philippines has two seasons, no? So the wet and the dry season, ano siya, conclusive evidence. Unsa pa man ang conclusive evidence? Conclusive evidence, like for example, the law on gravity. No? Kung unsa imong giitsa, mabalik din na dito sa ground. That's conclusive. So, man mo pag-contradict ang conclusive evidence. Unsa pa nang example sa conclusive evidence? Ginhawa pa. So that's it. This is examples of conclusive evidence. The circumstance, the law generally do not allow the same to be contradicted. Okay? Positive evidence. What is a positive evidence? It is evidence affirming a fact in issue. Meaning affirming. For example, eyewitness to a crime. Nakakita siya. No, nakakita siya nga gipatay ni Pedro si Juan. Nitestigo siya nga, oh, nakakita ko nga gipatay ni Pedro si Juan. The testimony of that witness is a positive evidence because it affirms a fact in issue. No? Ingon siya nga tinuod kana nga hitabo, tinuod nga si Pedro iyang gipatay si Juan. The testimony of that witness is a positive evidence. Now, negative evidence, bali po ni sa pikas, no? For example, testigo sa akusado. Moingon po ng testigo sa akusado nga nakakita ko, dili siya ang gapatay, dili si Pedro ang gapatay ni Juan. Okay? The testimony of that witness is a negative evidence. It denies the existence of a fact in issue. Now, what is the fact in issue in a case of murder, whether or not? In this case, Pedro killed Juan. Okay? Kung ang akusado ang mupresenta sa iyang testigo, ano siya nga, to ako dito, anang orasa, anang lugara, anang pitsaha, ug nakita nako si Pedro ug Juan anang higayuna, ug nakita nako nga wala gipatay ni Pedro si Juan. So the testimony of that witness is a negative testimony. It is a negative evidence. It denies the existence of a fact in issue. The denial of that witness is favorable to the accused because, syempre, in a prosecution, the accused in a prosecution of murder, okay, ang iyang trabaho ana is to deny the accusation against him, deny the charge against him. Okay, negative evidence. And we have rebutting evidence. Rebutting evidence that prima facie, no? Ang rebutting evidence, the evidence which you present to repel, counteract, contradict, or rebut, then that's rebutting evidence, no? Kini, posible ba nga ang ebidensya, no, upon assessment of the judge, stands in an equipoise? So we pronounce this as equipoise, no? Natay equipoise rule. Unsa man ang equipoise rule? Equiponderance of evidence or the equipoise rule. Kini siya, for example, if the evidence of the prosecution and evidence of the accused sits on a balance. Tanaw sa judge nga, priha man ang kabug-aton sa ebidensya sa akusado o ebidensya sa prosecution. Saan man naron sa judge in giving a decision, in issuing a judgment. Unsa man. So remember this, when the evidence of the prosecution and the accused stands in an equipoise, meaning in a balance, the judge will always resolve the same in favor of the accused. For example, sa criminal prosecution, no? Tanaw sa judge balanse ang ebidensya sa prosecution o sa akusado. Unsaon man niya nga balanse man? The judge will always pronounce the acquittal of the accused. Di niya i-convict. Iyag yung i-acquit ang akusado. Iyang i-acquit. The balance shall always be resolved in favor of the liberty of the accused. Iyag yun permi, kana, and the evidence of the prosecution sits on a balance which we call equipoise. The balance should be resolved in favor of the acquittal of the accused, no? Kung priha kabug-aton unsaon sa judge, dili mo ingon ang judge nga ako ning i-convict. Priha ra biya ni silang priha kabug-aton sa ebidensya. No. The judge is under obligation to pronounce the acquittal of the accused. Iyang yung buy-an ng akusado. Why? Because doubts in our law shall always be resolved in favor of the accused, no? Tanang mga agam-agam, tanang duda sa balaod nga pabor sa akusado, iresolba gina siya. Pirmi pabor sa akusado. Why? Because the Constitution very well protects the right of the people to liberty. Okay, we have the right to liberty, right to life, and right to property. Okay, so when confronted by an equipoy, the court must always pronounce the acquittal of the accused. Okay? Kay among all other rights, no? Gani ang liberty sa accused is protected by the Constitution, no? Mo na siya. So that's the equiponderance of evidence rule or the equipoy rule. So in criminal case, the accused will be acquitted. Now, how is circumstantial evidence established? It is established by simple inference from series of facts. O mo kung gingon sa inyo, inyong tahi-tahion ang mga tanang ebidensya, tanang circumstantial evidence, mga testimonial evidence, documentary evidence. So, in case there is no direct evidence and the prosecution will only rely on circumstantial evidence, so the court, in the appreciation of evidence, will consider a cumulative of all the evidence, cumulative, sum total of all evidence, sum total of all circumstances, of all circumstantial evidence in helping him or her arrive at a judgment. No? Circumstantial, tahi-tahion mo sa kini nga gipresenta nga testigo sa isa ka witness, kini siya, posible ba? Maka-create ba siya, maka-establish ba siya og fact na indeed the accused who is charged of the crime is guilty thereof. So muna siya. Okay? So reasonable inference from a series of facts, inference from a series of facts or circumstances. Kini, may a confession of accused be admissible against a co-accused? General, no. A confession cannot be used as evidence against a co-accused, for the same is considered hearsay. It may nevertheless be utilized as corroborative evidence of the existence of conspiracy among the accused in committing the crime. It is well settled rule, however, that although an extrajudicial confession is admissible only against the confessant, it is admissible as corroborative evidence of other facts that tend to establish the guilt of his co-accused. The implication of this rule is that there must be a finding of other circumstantial evidence which, when taken together with the confession, establishes the guilt of a co-accused beyond reasonable doubt. Okay. No, the rule is that a confession cannot be used as evidence against a co-accused because it is hearsay. Okay? But the same may be admitted in the presence of other circumstantial evidence. It may be admitted as a corroborative evidence. Okay? To establish the guilt of a co-accused in a conspiracy beyond reasonable doubt. Okay? Because in a conspiracy class, it is a general presumption that the act of one is the act of all. Okay, there is a concerted, there is a coherence of the mind of the act. No, the act of one is the act of all. Pero ang confession sa isa ka conspirator will not be admissible against a co-conspirator because the same is hearsay. What is the exception? The same confession may be admitted as a corroborative evidence provided that there are other circumstantial evidence present. Okay? So dili lang siya mao. Naapay lain nga circumstantial evidence na present nga will tend to establish the guilt of the accused beyond reasonable doubt. Okay? So that's always be beyond reasonable doubt. So nabay kalainan ang evidence of proof. Yes. Evidence is the means. Ang evidence is ang pamaagi unsaon nimo pag-establish sa kamatuoran, sa proof. Okay? Ang proof mo na siya epekto sa ebidensya. Okay? So ang proof is the result of introducing evidence. Muna na siya ang resulta sa tanan ni mga ebidensya. Like for example, ang kaso is murder. So nagpresenta ang prosecution og mga ebidensya karon napamatud-an nga ang akusado gyud ang nagpatay sa biktima. Okay? So the end result is what we call proof. Proof nga nagpamatuod nga ang akusado, charge of murder, siya gigapatay sa biktima. Unsa maning mga ebidensya ang means, meaning ang mga pamaagi nga na-establish to ang end result. Mga pamaagi nga gihatag, nga gipresenta, mga ebidensya nga gipresenta sa prosecution nga nakatabang nagpamatuod nga ang akusado tinud-anay nga guilty sa salaod. Usa pa, proof, the establishment of a requisite degree of belief in the mind of the judge to the fact in issue. So proof mo na siya ang end result sa tanang evidence. So ang appreciate ani is ang judge na, no? Ang duty sa lawyers is to present evidence on the part of the prosecution to convince the judge that the accused is guilty of the crime. On the part of the defense counsel is to convince the judge that the accused is not guilty of the crime. Okay, once the judge issues a verdict, no? If the verdict is for acquittal, meaning napamatuod nga katong verdict sa judge, proof nga wala na-commit sa akusado ang krimen. No? It's a requisite degree of belief in the mind of the judge. Now, under the RPC, evidence is defined as the means, okay, sanctioned by the rules, mga pamaagi, unsaon pagkumbinsi sa hukmanan na ang imong kliyente na walay sala sa salaod. Muna siya sa part sa defense. O on the part of the prosecution, unsaon pagkumbinsi sa hukmanan na ang imong kliyente, ang complainant, ang private complainant, okay, sakto sa iyang aligasyon ng akusado, mooy naka-commit sa salaod. Ano siya? Ang proof muna na siya accumulation of evidence sufficient to persuade the trial court. Muna na siya, ang proof muna na siya resulta sa katibuk-an nga ebidensya nga gipresenta sa korte. Muna na siya resulta. Okay. So the purpose of evidence is to establish proof. Okay, again, on the part of the prosecution to convince the court that the accused is guilty of the crime. Sa bahin po sa akusado, okay, tanan niyang ebidensya para magpamatuod nga siya walay sala. Sumuna siya. So the end results, kung asa mo dapit ang hukmanan, mo na siya ang end result, mo na siya ang proof. Now, unsay kalainan sa quantum of evidence, sa quantum of proof. So, sa quantum of proof it refers to the degree of proof required to order to arrive at a conclusion. Ang quantum of evidence, it is the totality of evidence presented for consideration. Ang burden of evidence, in a criminal prosecution class, the burden of evidence is always on the prosecution, no? Okay. In every criminal prosecution class, sa unsa man mga krimen nga i-prosecute niya sa korte, okay? The burden of proof never shifts, okay? The burden is always on the prosecution to prove the guilt of the accused beyond reasonable doubt. Maski pa unsa kahinay ang ebidensya sa akusado, dili na makaapekto. Okay, dili na makaapekto. Kay ang duty tua sa prosecution nga iyang i-establish ang guilt sa accused beyond reasonable doubt. Pwede gani nga i-waive na sa akusado ang pagpresenta sa iyang ebidensya? No? Kung dili lang mangani kusog yung ebidensya, pwede man nimo i-waive. Okay? Pwede man i-waive sa akusado, pwede man siya moingon nga he is waiving his right to present evidence and there's no problem with that. Kaya ang duty, perme, in every criminal prosecution, ang trabaho tua sa prosecution nga iyang pamatud-an sa hukmanan nga ang akusado maoy guilty sa salaod, no? Trabaho na sa prosecution, and this burden of evidence never shifts, no? Ang burden of evidence never shifts. It's always on the prosecution to prove the guilt of the accused beyond reasonable doubt. When the prosecution fails to prove the guilt of the accused beyond reasonable doubt, no? Kung there is failure on the part of the prosecution, dili niya mapamatud-an ang guilt sa accused beyond reasonable doubt, then there is a corresponding duty on the part of the court to pronounce the acquittal of the accused. Acquitted din na permit class, no? Kung dili mapamatud-an or kung naamang gani na create sa doubts, na create sa mind sa judge nga doubt, misking unsa kagamay. Okay? Whenever doubt, no matter how minute, is created in the mind of a judge, that doubt shall always be resolved in favor of the acquittal of the accused. So, that is how our right to liberty is protected by the Constitution. That we cannot just be deprived of it without the prosecution proving the same beyond reasonable doubt. So, muna siya ang quantum of proof required. No? We can only pronounce the guilt of the accused when the same is proven by the prosecution beyond reasonable doubt. So, misking unsa kagamay nga duda nga ma-create sa defense, sa mind sa huwes, sa hukmanan, kana nga duda shall always be resolved in favor of the acquittal of the accused. Pirme acquitted ang accused class kung naay duda maski gamay sa nga magpabilin sa unang-una sa hukmanan. So that is how precious our right to liberty is. Okay? So criminal action, unsa may mga quantum of proof required. Sa criminal action, it is proof beyond reasonable doubt. Civil action, it only requires preponderance of evidence kung asay mas bugat nga ebidensya. Sa administrative action gani, sufficient evidence ang kinahanglan. So there's nanay ko definition diha. So naabay the distinction sa factum probandum ug factum probans. Ang factum probandum, that's the ultimate fact. Muna siya proof. Ang factum probans, muna siya evidentiary fact. No? Factum, these are just Latin terms. Factum probandum, muna siya imong proof. Ang factum probans, muna siya imong mga evidentiary facts. Ang imong mga ebidensya nga gipresenta para mapamatud-an ang usa ka fact. So there is that definition, a distinction between factum probandum and factum probans. Okay, you can take note of that. Are the rules of evidence in criminal and civil cases the same? Yes. The rules of evidence in criminal and civil cases are the same, except that the quantum of proofs required are different. So when is evidence admissible? Again, it is admissible if it is relevant and it's not excluded by the law or the rules. So is there a difference between admissibility and credibility? So yes, there is, no? Kaya posible man ang ebidensya credible, pero dili siya admissible. Kaya in the first place, na-obtain siya in violation of the law, the rules, or the rights of the accused. Credible unta siya, pero dawaton kay naka-violate. Nya, kining admissible. Pwede ba ang ebidensya admissible? Yes, admissible siya. Pwede siya admissible, pero dili siya credible. No? Dili siya admissible. Admissible unta siya, kay walay violation. Ang credibility, diha na during cross-examination, redirect examination, nabungkag ang testimonya because there are material inconsistencies in the testimonies sa witnesses, for example. So admissible unta ang ebidensya pero naapektuhan ang credibility kay during examination, during cross-examination, redirect examination, nabungkag man ang testimonya. So admissible unta pero nawad ang credibility because of, for example, material inconsistencies in the testimonies of the witnesses. Yeah, pwede po siya nga ang ebidensya unta credible pero dili admissible. Credible siya unta makatabang sa kaso, dili lang siya admissible kay na-obtain in violation of the law, the rules, or the rights of the accused. If evidence is admissible, does it follow that it has probative value? So, dili, no? Ang admissibility of evidence has nothing to do with its probability value. Muna akong gingon sa inyo na ang ebidensya unta admissible pero dili makatabang kay wala siya, dili siya credible, dili pud siya maka-add sa weight sa evidence sa prosecution sa proponent sa evidence. So mura na siya. Napod untay bugat nga mga ebidensya nga bugat unta credible makatabang og strengthen sa case sa proponent sa ebidensya pero dili siya admissible kay in the first place pag obtain na violation. So muna siya. Is evidence obtained by entrapment and instigation admissible? Yes. So entrapment operations like buy-bust operation no nga common kay sa ato karon, mga operations buy-bust drug operations sa atong mga kapulisan. So those are entrapment operation and the evidence obtained obtained as a result of the entrapment operation is admissible in evidence. Pero pag instigation gani class, dili siya admissible no. Lain ang entrapment, lain ang instigation. Pag entrapment admissible, pag instigation it is inadmissible. Is evidence obtained without a search warrant admissible? Generally, no. But there are illegally obtained evidence is inadmissible. Fruit of a poisonous tree. So, unsa exception ani? Caught in flagrante delicto. Okay. So, kung nakakuha kang ebidensya by virtue nga walay search warrant, dili siya admissible. No, kay fruit of a poisonous tree. Unsa exception? Flagrante delicto. Mga flagrante delicto arrests. So, evidence obtained during flagrante delicto arrests are admissible in evidence. Evidence obtained through uncounseled confession admissible? No. Confession obtained in violation of the Constitution is inadmissible. Muna akong gingon class. Tanang ebidensya nga na-obtain in violation of the constitutional rights of the accused, in violation of the rules on evidence, in violation of existing law, they are not admissible. What is multiple admissibility of evidence? It means that evidence is relevant and competent for two or more purposes. No? Multiple, meaning more than one. It was said that if evidence is relevant and competent for two purposes, such will be received if it satisfies all the requirements prescribed by law. Okay? So, multiple admissibility of evidence. Pwede naman ang evidence, ang purpose of presentation of evidence, not just for one purpose, but for some other purposes. And when the evidence is admissible for more than one purpose, then na siya multiple admissibility. Conditional admissibility, it means that evidence that which appears to be immaterial is admitted by the court, subject to the condition that its connection with other facts subsequently to be proved will be established. So, na conditional admissibility nga initially in the course of the trial, na gi-offer nga evidence but somehow it appears inadmissible, irrelevant. Pero the counsel will move for the admission of the same, for the admission of the same on the condition that later on it will be connected to some other points which will appear material to the case. Kanang curative evidence class, curative meaning kanang makaayo ba? Okay, evidence nga una improper is admitted to contradict improper evidence introduced by the other party. Okay, curative. So the purpose of which is to cure an otherwise an improperly offered evidence. Collateral matters. So many mga collateral matters class. Okay? Like for example, na kay mga collateral relatives, di ba? Kana mga sanga-sanga na ba? Sanga-sanga. So you have direct matters and you have collateral matters, mga side bit. So there are those other than the facts in issue and which are offered as basis for inference as to existence or non-existence of the facts in issue. Again, evidence on collateral matters not allowed except when they tend to prove in any reasonable degree the existence or non-existence of the fact in issue. May collateral matters be allowed in evidence? As a rule, no. or to exempt when they tend in any reasonable degree to establish, okay. Collateral matters are classified into antecedent circumstances, so facts existing before antecedent. Concomitant, facts existing during, okay, the commission of the crime. Subsequent circumstances, meaning after the existence of the crime, after the commission of the crime. So we have antecedent, meaning ante, before. Concomitant, meaning concurring, during. Concomitant, you can say concurring at the same time. Then subsequent, meaning after the fact of the commission of the crime. So these are kinds of the classification of collateral matters. Now, are there questions? Do you have any questions?
None, ma'am.
None, ma'am.
Okay. So, klaro ra?
Yes, ma'am.
Okay. So, so the most important thing is you familiarize yourselves with the concept. Okay, familiarize and memorize the concepts. Hello, Ma'am Kim? Hello? Hello?
Naka-out na ito si Ma'am Kim, ma'am.
Naka-out na. So, wala man kayong mga pangutana? So, are there no questions? Ha?
Pwede mga copy ni ma'am.
Yeah. Can they get a copy? Makakuha sa copy ni? Okay. You just coordinate with your Sir Morong, ha?
Okay, ma'am. Thank you.
Okay. Sige. So, kung wala na yung mga pangutana, okay, I will adjourn the class. Thank you.
Okay, ma'am. Bye, ma'am.
Okay. Sige. Okay.
Thank you, ma'am.
Sige, mag-iwas ko yan.
Thank you, ma'am. Thank you.
Are we late?
Ay, ubay.